Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Klossing.
When will a divorce court or a taxing authority set aside a fraudulent property transfer, and can you provide an example? Transfers that are made by a spouse who's going through a period of marital difficulty can be set aside by either a divorce court or possibly even a taxing authority. Where a transfer of property is made solely by one spouse during a marriage, and this happens during a period of marital difficulty or marital strife, whether or not divorce is on the horizon at the time, might be held to have not been made unconditionally by the non-donor spouse. In other words, the spouse that didn't acquiesce to the transfer of property. This can result in a reimbursement requirement to the non-donor spouse being imposed on the donor spouse. In other words, the spouse that gave away the asset can wind up having a reimbursement requirement out of the remaining community property to the non-donor spouse, the spouse who didn't want to give the asset away, in the divorce proceeding. Moreover, in the majority of states, the non-donor spouse may have legally set aside a gratuitous transfer of property made during a period of marital strife as a deemed fraudulent transfer. What does this mean? You're fighting with your spouse. All of a sudden they give away your vacation property, that's half community property, to a friend. If you guys are fighting like crazy and you didn't acquiesce to that gift, it is possible to either get the property back through the divorce proceeding, have it be brought back into the marital estate, or at least get reimbursed out of other community property assets for the gift that you didn't acquiesce to or agree with. Here's a case I'm going to give as an example of this legal concept. This is Marjorie Reed Harper, TC Memo 1993-126. In 1981, the husband in a couple was audited over suspected unreported income related to illegal drug trafficking. Evidently, to do damage control, husband and wife fast-tracked a divorce in July of 1981. Husband was not present during the divorce proceeding, but filed an answer and a waiver, and a division of property was not even requested by the parties in the divorce proceeding. The presiding family law judge was not made aware that a property settlement was even on the horizon for the couple. The judge went so far as to warn the wife that she could not seek any type of support from the husband and dissolve the marriage. In August of 1981, the husband transferred his ownership of real property to his wife's daughter, and the conveyance read, "Conveyance pursuant to property settlement agreement and dissolution of marriage." This is quite interesting and will become operative in that no property settlement was part of the divorce proceeding. Later in 1981, September of 1981, the husband transferred to the wife various assets that he owned without consideration. Immediately following these transfers, the husband was left insolvent. In 1985, the husband was indicted for tax fraud and was incarcerated for 18 months. In 1990, the IRS comes along and makes a jeopardy assessment against the wife. Because she's a transferee of assets from the husband, she filed a statutory notice of deficiency to contest the jeopardy assessment, which led to the court action that I'm discussing with you now. Citing Phillips versus the Commissioner, the court held that pursuant to Code Section 6901A1 Cap A, the IRS may collect from a transferee of assets, the wife in this case, the unpaid income tax liability of the transferor, the husband. Case law has previously defined a transferee as an individual who takes or receives property of another without full, fair, and adequate consideration to the prejudice of creditors. In this case, the United States was a creditor trying to collect restitution for tax fraud. This premise came out of the United States versus Flourish, 276 Federal 2nd, 714, 717. Where the IRS meets its burden of proof, the transferee, the wife in this case, becomes liable for the transferor's taxes that are owed up until the transfer, as well as to additions to tax, penalties, and interest, but this is all limited to the amount of assets that the wife received from the husband. The IRS is required to rely on state law to make a determination of the transferee's liability for the transferor's obligation. This case took place in Florida. Under Florida law, gifts and transfers made for the purpose of the intent to delay, hinder, or defraud creditors are void as a matter of law. This comes out of Shad versus Commissioner 87 TC 609-614, 1986. Florida fraudulent conveyances law lists the following badges of fraud: the existence or threat of litigation at the time the transfer is made, a familial relationship between the transferor and transferee, grossly inadequate or a complete lack of consideration, secrecy and the concealment of an asset transferred. The court pointed to the following badges of fraud in holding for the IRS in this case. At the time the husband made the transfers to the wife that are deemed to be fraudulent in this case, he was substantially indebted to the government and was insolvent at the time that he made the transfers to the wife. The transfer from husband to wife lacked consideration, there was no money paid between the parties, and the transfer was to a family member. The husband was aware that the IRS was auditing him at the time of the transfers regard to substantial unpaid federal tax liabilities, potentially leading to criminal exposure. Another way a divorce court, or a taxing authority for that matter, can set aside a fraudulent conveyance is to argue that the party that the assets are transferred to is really just the alter ego or nominee of the transferor. Relevant factors a court will look at in making this determination include the following: whether the acquiring taxpayer used their own personal funds to acquire the property that was transferred, the adequacy and source of consideration paid for the transferred asset, the likelihood that the property was placed in the nominee's name in anticipation of a collection action from a creditor, whether the acquiring party, or rather the transferor, constructively enjoyed the benefits of possession and control over the property. An example of this would be where a husband gives away asset to a friend, let's say his Ferrari. He just gifts it outright to him, but it's never parked in his friend's driveway, it's always in his driveway. The husband's always driving the car. There's absolutely no change in his use over the asset. This could be seen as his constructive enjoyment of that asset, therefore a fraudulent conveyance. Other considerations the court will look at to figure out if an alter ego or nominee is involved. They're going to look at the relationship between the taxpayer and the acquiring party. They're going to look at the formalities, or rather lack thereof, over the transfer of ownership. The court's going to want to know who's paying the maintenance expenses, who's using the property as collateral for a loan, who's paying state and local taxes on the property. If this all comes back to the transferor rather than the nominee third party, you're going to be dealing with an alter ego or nominee situation.